Okay, welcome everyone. Welcome people on the live stream. We have a few people in the live venue who are visiting the bar back there, I'm sure getting their soft drinks and perhaps their water. But I wanted to get started for those of you who are tuning in on the live stream. I am Cathy Blackburn of lifeplanlaw.com. Before I start, those of you on the live stream won't be able to see them, but the live people will. I want to acknowledge very strongly the guys that put all this together, Tony and Andrew. Give them a big hand. And Jacob behind the bar back there. For those of you who do not follow astrology, Mercury is retrograde, and we could prove it now, today, with all the things that have gone wrong with the technology. And I also want to introduce to you Colleen McIntosh, if you would come over here in front of the camera so that people Colleen is a lawyer with us. And so we are all here today to make sure that you get something of value for yourselves today about life planning for the LGBT community. So I will go ahead and get started. This being Pride Month, I decided to add a few things to set the context of where we are in the world of LGBT rights and LGBT planning. So everyone has a history. You and I do, everyone here does, and our community also has a history. And in setting the context, I wanted to go through just a little bit of history with the LGBT community, beginning with what you probably recognize as the Stonewall Rebellion in 1969 in New York. Now, what you may or may not be ultimately familiar with is this is a photograph of Brandon Tina, a trans man who was murdered in 1972. And this is Harvey Milk, a candidate for supervisor in San Francisco, who was murdered in 1978. It isn't all bad, but we do have a varied history. Does anybody recognize this? This is the AIDS quilt that was laid out at the National March on Washington in 1987. Do we remember the AIDS crisis? We should. It's one of those things we should never forget. This is Lieutenant Dan Choi at the National Equality March in 2009. Things get a little more positive here for a while. Not so much here with 49 people murdered at Pulse in 2016. Now, when we start to talk about LGBT rights and we start to talk about LGBT life planning, it is somewhat important to know the context of the legal rights for the LGBT community. This is a Supreme Court case from 1986, Bowers versus Hardwick, that said it is constitutional to put gay people in jail for having sex. This is the case that reversed that, Lawrence versus Texas, which was in 2003. So it took that long to understand that Bowers versus Hardwick was wrong and to reverse it in Lawrence versus Texas and hold in a series of cases. This is the first in the series of cases, the 5-4 decisions in which Justice Anthony Kennedy was the deciding vote at the Supreme Court in favor of LGBT rights, and this said you can't criminalize gay sex. Do we remember her? Anita Bryant. And then in 1972, Florida passed a statute that said that gay people cannot adopt. And it took until 2010 for an appellate court in Florida to strike that down and change the law that said that gay people can adopt. What you may not know about this is an intermediate appellate decision in Florida out of Miami in the 3rd District Court of Appeals. The Florida Department of Children and Families did not appeal this case. DCF had always been in favor of allowing LGBT people to adopt. And they prevailed and did not appeal this, and so the ban on gay adoption went down in Florida in 2010. And those are the plaintiffs and their son who brought the case that struck down the ban in Florida. Then in 1996, the United States Congress got a little freaked out and passed the Federal Defense of Marriage Act, the infamous DOMA, banning recognition of same-sex marriage anywhere in the United States, and that was then struck down in 2012 in United States versus Windsor, yay, Edie Windsor. So that was 2012. Then, in 2015, the Supreme Court in Obergefell versus Hodges ruled that states cannot ban same-sex marriage, and marriage equality became the law of the land in 2015. It seems like that was yesterday, but it really was 6 years ago. I thought we would never see the White House lit up in rainbow colors again, but under this administration we might. And this is James Obergefell with his lawyer after the Obergefell decision. Now this is a decision from 2020. Was the opinion? Yeah, it was decided June 15, 2020. There were 3 cases that were consolidated before the United States Supreme Court, and this held that Title VII protects sexual orientation and gender identity. So the 1960s Employment Anti-Discrimination Statute, Title VII, now explicitly applies to gay and lesbian and transgender people. And believe it or not, Gorsuch was the justice who wrote this opinion. Now, you don't want to read too much into this, because after this, we now have this year, after this legislative session, our governor, DeSantis, signed a bill banning transgender youth from playing sports. And he also signed or vetoed funds for counseling for survivors of the Pulse massacre. And he also vetoed $50,000, a mere $50,000 in the budget of the entire state of Florida, line item veto that would go to housing for homeless LGBTQ youth. And now we have the decision that was just handed down a few days ago, June 17, 2021, Fulton versus City of Philadelphia. I don't know if you've read about this opinion. This opinion is, the actual holding, I think, is unanimous on it. The liberal justices joined with conservative justices and Chief Justice Roberts to rule that Catholic social services in Philadelphia must be given a contract for clearing foster parents, even though they discriminate against LGBTQ foster parents. This is a very, very complicated opinion. And yes? Can explain it a little bit, the opinion? Well, what happened is that Chief Justice Roberts managed to steer the court into dodging a bullet. So the bullet is a case from the 90s, and I think it was literally 1990, which was against a Native American spiritual group that appealed to the United States Supreme Court and said that, I believe it was the state of Arizona, cannot prohibit us from using peyote in our religious observances. And the court said that the state, because, Kathy, it's not my personal opinion is they didn't want people smoking peyote. So they decided that as long as the state statute is broad-based and doesn't discriminate specifically against religion, you can have a statute that applies to religious observances. So hence, the Native American religious group could not smoke peyote. Well, if we apply that same principle here to the city of Philadelphia that had an ordinance that says that if you contract with us, you cannot discriminate, including on the basis of sexual orientation and gender identity. But Catholic Social Services blatantly discriminates on those bases. So there were a number of justices, including Gorsuch, including Alito, of course Clarence Thomas leading the way, Kavanaugh, Barrett, etc., who want to reverse that opinion. Now, if you reverse that opinion, it's open season on gay people. But Roberts apparently, so it is speculated, did not want to be known as the bigotry court. And so he managed to steer the opinion on very narrow grounds. So the Fulton decision says, well, Philadelphia's ordinance is not broad-based and neutral and doesn't apply to everybody because in the contracts you can have exceptions. Therefore, it just doesn't apply to Catholic Social Services, and therefore you have to continue contracting with Catholic Social Services. Get ready, because the conflict between so-called religious freedom and, quite frankly, gay rights. I don't know that there are the rights of other minorities that religions claim we should discriminate against, but they claim that we should discriminate against gay people, and that's our religious freedom to do so. And so there are a number of members of the United States Supreme Court, probably a majority, who would like to make that the law of the land. So Fulton dodged a bullet, and that is why the liberal justices joined in the opinion to avoid a worse opinion. In Fulton, it's interesting, that was only 2 days ago that they came down with that decision. So here we are with a mix of decisions. All of this is part of our history. And I think it's really clear that LGBTQ people have not been included in the laws of the United States or the political processes for most of our history. And much of the progress in the laws has been made in the 2000s. So people sometimes, it used to be really frequently as soon as Trump was elected, it's died off a little bit now, people asking me, will they reverse marriage equality? And I can't tell you the answer to that. Personally, I don't see any way you can reverse marriage equality. You're going to see throughout this presentation how much the relationships, social relationships between people is governed by the laws of marriage. And we've now had this for a long time in several states, and since 2015 across the United States, and I don't think you can unwind it. Even if you wanted to reverse the principle, you don't know how you unwind the consequences. So I don't think they're coming after marriage equality. Quite frankly, my personal opinion is they're coming after blatant discrimination in the name of religious liberty. So where do all these things fall in our default rules of law in this context of United States law? Well, we have a number of areas of life that life planning touches upon. And so all of the default rules of law that apply in the area of marriage and homestead and probate and guardianship and asset protection and adoption and custody and taxes and Medicaid and different kinds of benefits now apply if you're married. And this is just a partial list of it. So I don't think, as I said, I don't think we can reverse this. We can't unwind it. But I suppose they could say, going forward, you just don't get this anymore. So in the area of marriage, marriage brings a number of default rules with it, including the fact that a spouse is presumed to be the first healthcare surrogate. A spouse is presumed to have the first preference to serve as the personal representative of an estate, which is, some people call that the executor. A spouse will be the first person to inherit outside of a will, and you still have rights as a spouse, even if there is a will that even cuts you out of it. I'm going to go over that later. We have presumed parenthood, although none of the adoption attorneys that I know are relying upon presumed parenthood. It's presumed that if you are married, the spouse of the woman who gives birth is presumed to be the parent. Nobody's trusting it in same-sex couples. You get joint property rights and many other rights with marriage. The laws and the rules and the procedures that apply to divorce also apply if one is married. So we were in that conundrum prior to 2015. If you're married in New York, but you live in Florida, how do you get divorced? That was not an easy thing. We managed it some way. So, homestead rights. Now, you all know about the homestead tax exemption, where you get a little bit, seemingly minuscule, deduction on your homestead, on your property taxes. But there are many other rights that come with homestead in Florida. Some of those involve marriage. So, if you don't already know this, let me be the first to tell you, you cannot disinherit your spouse in Florida. They have to waive it knowingly. They can do that. But you can't just disinherit them. Don't try it. It'll get worse. Right? You can't disinherit your minor children. Homestead has creditor protections. So, if you have a homestead that passes from you to a spouse or a blood relative, that blood relative will take that house free of your creditors and free of their creditors, free of the deceased person's creditors and free of yours. Really nice benefit in Florida. That comes with marriage, but it also comes with leaving your homestead to anybody who's an heir at law, which is typically a blood relative. In probate, you have a preference for the spouse to serve as the personal representative. After that, it falls, the preferences fall to blood relatives. Inheritance also goes to spouse and children. I'm going to go over that in a little bit more detail. And blood relatives. If you don't want this, you have to do a will. If you don't want things going to blood relatives in the order that the state of Florida says, you need to do a will. Guardianship, I don't often talk a lot about guardianship. Guardianship, the spouse is the preferred first guardian. Has anybody had any experience with guardianship of any sort? You would raise your hand fast if you had, because it's horrible. It's a terrible experience. And it's an expensive court proceeding. It takes away everybody's rights, whether that's fair or not, and then turns them over to somebody else, and good luck whether that person really takes care of the incapacitated person or simply steals the money.
My partner and I raised her granddaughter, and she's an attorney, and she went to the court, but didn't ask for guardianship. First of all, we had all the parties concerned, the biological parents, the grandparents, and myself and my partner. And my partner went to the court and asked for custody, current custody.
Right.
We first had the child evaluated, everybody else evaluated by a therapist to say that, hey, my partner and I would probably be the best couple to raise the child. So we sort of avoided guardianship. We just went to the court and asked for custody. I guess.
Right.
Is that what you?
Well, the question, for those of you who didn't hear it, has to do with custody, with guardianship of a minor. And her partner, she and her partner had custody of the partner's granddaughter. And then in seeking a legal basis for that, went for permanent custody instead of guardianship. And guardianship of a minor is also a big morass, and often hotly contested. You don't have to be declared incapacitated when you're a minor, because you are legally incapacitated anyway, because you can't enforce your own legal rights until you're 18. So that's a very common procedure in minor situations. And in addition, I don't know if you got money from the state to help to raise her or benefits for her, but those would be cut off if you adopted her, whereas with permanent custody, they're not. So you get some benefits by seeking permanent custody of a minor. But that, again, is a very complicated area of law. And good for you. Did she turn out great?
She's had some problems.
You've done your best. At least she's safe and well cared for. Yes. Yeah. So in the area of asset protection, believe it or not, if you have come to speak to me, I've probably told you about this. Whether you understood it or not, I don't know. But in Florida, it might be unique to Florida. It is not common. But in Florida, property owned jointly by a married couple is protected from individual creditors. Now, this is why all the doctors have all their property in joint names. Because if they are sued, they can't come after any of the joint property. But I'm going to suggest to you that your automobile is a greater liability than any doctor ever faces. Because in Florida, the owner of the automobile is responsible for everything that happens with it. So my suggestion to married couples always is hold your cars in separate names. Because if there's a big old wreck, it doesn't even have to be your fault, but if there's a big old wreck with one of the cars, they can't come after your joint property. Now, there are some exceptions to that. If one of you owns it and the other one is driving it, well, all bets are off because now the owner and the driver are responsible. But if you mostly drive your car and you own your car and something happens with your car, they cannot come after your joint property. Nice asset protection. Very simple. Just have your car in your own name. In the area of adoption, there is one process for a married couple. There's one fee There are preferences in adoption for blood relatives. On that, I'm not going to get too much into adoption here. Custody, similar things. There's always a preference for blood relation in custody issues. Of course, the other bio parent is going to have, both bio parents are going to have rights in custody. In the area of taxes, when you're married, you're tied together, at least in some way, for taxes. Even if you don't file jointly, even if you don't file married filing jointly, you file married filing separately, your taxes are still calculated a little differently than strictly single people. So sometimes we call that the marriage penalty, but you are in some ways tied together for taxes. And then in the area of benefits, now, well, Medicaid ICP. ICP stands for Institutional Care Program. Here I'm talking about nursing home care for Medicaid. When I used to talk about marriage equality before the Supreme Court decision in Obergefell, and then shortly afterward, what I said to people was, in my personal view, personal only, being married is a personal choice. If that is an expression for you, you should do it. I don't see a reason financially to get married, except if one partner needs nursing home care, because there is an unlimited exemption for spousal transfers for Medicaid. Now, what that means is that if your spouse has $10 million and needs nursing home care, we can move that $10 million to you, and she will qualify for Medicaid. Unlimited, very large amount. So that's very, very beneficial for people. You also get a monthly maintenance allowance for a spouse. You get a community spouse asset allowance. There are some disabled child exemptions. These do not apply if you're not married. And then, of course, we all know that many employers and even Social Security and some others provide joint or automatic health insurance and retirement, veterans benefits, etc. If anyone is a veteran, or you have a spouse, or you are the surviving spouse of a veteran and you need help with activities of daily living, you should speak to someone about VA, aid, AID, and attendance. There's a really nice benefit if someone is a veteran or the spouse of a veteran if you need help. You can get up to $1,200 a month for a spouse and a little over $1,900 a month for the veteran. So don't omit veterans benefits. And if you don't already know about how to work the Social Security system to help with spouses, ask a financial planner. They know more than me. I just know there are ways to maximize Social Security benefits. Now, these default rules of law are different if you're not married. So, in the area of marriage, there are no standard rules or procedures for the breakup of unmarried couples. And I'm just going to tell you this, there is no palimony in Florida. Florida law is hostile to unmarried relationships. And that has grown up in the area of heterosexual relationships. It's not discriminatory against LGBT, it's just hostile. I won't tell you there's nothing, but please do not assume that if you've been in a 30-year relationship with someone, you get part of their assets. Homestead, the creditor protection is only available for you. It's not available for a spouse. If you die without a will, your home is going to pass first to your children, then to your parents, then to your siblings, and then to more remote relatives. So, if you are not married, you need to do something about your homestead, or it's going to go to your blood relatives. Probate, again, the whole probate process is going to be under the control of blood relatives. If you die without a will, intestate, we say, first your adult children will be your PR, then your parents, then your siblings, and then more remote people.
I have a question. Does it, when it comes to the siblings, do all of them get involved in it? Like I'm from a family of 7. So do all of them come to a meeting or something and they decide, or how's that work?
Pretty much. So the question is, if you die without a will and you have a bunch of siblings, do we have to now have vegetable soup and everybody gets a say in all of that? And the answer to that is pretty much yes. So that is a reason to do a will. So, I mean, I have hunted people down in the woods when they're homeless to get them to sign off on people taking care of a probate. I have gone to see them in jail when we've tried to find them. So if you do a will, you get to name the person who will be the personal representative. And if you have a bunch of people, you have a bunch of children, you have a bunch of siblings, please do that. Or we're going to have to somehow sort them all out. Another question?
Can I go back to homestead? If the home is in both your names, does...
None of that, what I said doesn't apply if the house is in both of your names.
Okay.
If the house is in both of your names, one of you, well, if it's a joint in survivorship deed,
Yeah, it is.
then it goes to the other owner. Okay. Yeah. For guardianship, now your guardianship, and I'm talking about adult guardianship here, is going to be under the control of blood relatives. Those of you who've talked to me, I probably asked you, do you have any relatives that you think are going to try to interfere with your plans? Because we can do a document called a pre-need designation of guardian. Now, I don't do a pre-need designation of guardian because I think you'll need a guardian. I don't do it because I think that, you should nominate somebody just in case. I do it to cut people out. So here's the game. You set up healthcare directives, you set up a power of attorney, you have a will, you have a revocable trust, and everything is copacetic, and you have diminished capacity or lack of capacity, and now some interfering relative wants to get control of you and your money. The game is they will petition for guardianship. And now we have a knockdown bloody battle on our hands. So I named somebody else as the pre-need guardian. And we simply kiss them goodbye and be done with it. So that game is over if we name somebody else. And frankly, I do pre-need designation of guardians for that purpose, not because I think you'll need one. I do it so we can wave it in front of the interfering person and say, have at it, you're not it. Spend your $10,000 to try to get a guardianship, but in the end, it's going to be somebody else. So, and in guardianship, they're going to control your finances, your health care, your living arrangements, your social relationships, everything about it. You don't want it. There are no specific asset protection rules, except homestead, of course, if you're not married. Adoption, singles, of course, can adopt. Be careful if you have a live-in partner. You want to be careful who does the clearance for adoption under those circumstances. I don't do adoptions. My understanding is we're not having a lot of trouble with that right now, but I don't know what the future brings. It's somewhat subjective. Custody, your partner has no custody rights.
What if you're married?
If you're married, the lawyers that I know who do child custody and adoption recommend doing a step-parent or a second-parent adoption. Okay, that is ironclad. And it's much easier than doing a flat-out adoption. I'm sorry that people have to go through that difficulty and expense, but everybody recommends it. Yes?
I live in Maryland, and my partner and I were custody, and if I recall correctly, we had equal custody. So this is different.
Well, that's because the court gave you custody.
Right.
Yeah, if a court issues an order of that, fine. But you don't get automatic rights without that. And in Florida, there are no grandparent rights. Now, grandparent could be granted custody, but if you don't have custody, there are no grandparent rights. So, you're really dealing with bio parents unless they waive, and then you want some kind of ironclad legal process that will now tell you who has custody. In the area of taxes, if you're not married, you don't have any joint taxes, there are no tax penalties, no tax benefits. Under very, very specific and limited circumstances, you could claim an adult as a dependent, but it's very limited. Medicaid, ICP, the spousal exemption is not available. However, there are many options to have people qualify for Medicaid, so don't give up. If somebody needs help in a nursing home at $10,000 a month or more, by all means see an elder law attorney and let's see what we can do to preserve your assets. Benefits, largely, couples don't get benefits. There's usually no joint benefits. Some employers are still recognizing domestic partner benefits, even if you're not married. So, what do you need to tidy all this up and make sure that everything that you want done gets done? So here are planning documents that everybody should have. Everyone should have a healthcare surrogate designation. And you need to have a backup to that person. The person you're probably going to nominate first as your healthcare surrogate is someone you spend a lot of time with, and if you're in the same car wreck and in the same emergency room, you want a backup to that. So if that person is not available, you should have a backup. You should have a living will if you want one. I almost never encounter people who do not want a living will, and they're not that easy really to understand. In the simplest terms, what a living will says is that if I am at the end of life and two doctors verify that I am not going to recover, then I decline measures that just prolong my dying. If I'm not going to recover, no feeding tubes, no ventilators. For me, no IVs, no non-palliative surgery, turn off the pacemakers, let me go. That's what a living will is. The piece that's kind of confusing, and it came up early in COVID. We're all numb to COVID now. That's kind of sad. We shouldn't be, but we are. Me too. But when COVID first hit, it was, but what if I get COVID and I have a living will? Well, if a ventilator is treatment and you are likely going to recover, you get the treatment. Only after treatment fails and the doctors acknowledge that there's nothing more that can be done does a living will even come in. A living will is not a DNR. DNRs do not resuscitate. I get 40-year-olds come in my office and say, I want a DNR. And I say, really, I don't think you do. Because if you grab this electrical cord and your heart stops, CPR will bring you right back. You don't want that? Well, that's not what I mean. We confuse that. Do not resuscitate means if your heart stops, no one's going to do anything about it. So you don't want a DNR until you've already made the choice that you're not going to do any heroic measures, and if your heart stops, you're ready to depart. So, but if you do not have a living will, you will be Terry Shiloh. We will be arguing about what you wanted. So please write it down. Do a living will. Everyone needs a power of attorney. A power of attorney handles financial and contract matters. I have a personal philosophy about powers of attorney, about life plan documents in general. I think that they should be very broad and very powerful. The power of attorney in Florida is effective as soon as you sign it. It does not wait for you to be incapacitated. So, as soon as you sign it, if that person has it in their paw, they can use it. So is there a risk? Yes, there is. So we want to minimize that risk in several ways. First of all, the first line is, who are we going to choose to be named as the agent under the power of attorney? Let's choose someone who's completely trustable. And if we have any questions, let's appoint two and make them act together. And if you don't want to do that, then I and many attorneys will hold the original power of attorney for you. If people can't use what they don't have. So you have what I call an escrow letter that says, Dear Attorney Blackburn, you're holding my power of attorney. If I am incapacitated or I'm in the hospital or there are other good reasons, hand it over, otherwise you keep it. So we can also do that to keep it safe. But I think you should have one because we just don't know what could happen. And if you don't have capacity, you need someone who can sign for you. Everyone should have a will. People say, I don't have much. Why do I need a will? Okay, if you don't have much, you need a will more than people who have a lot. People who have a lot can pay for the fight over it. If you don't have a lot, all the pennies of what you do have is going to go to the fight over it. And if you think people won't fight over $5,000, you're not living in the real world. They will. And, even if, now, you say I don't have a will, but you do. And it's written by the state of Florida. And you may not like it. So, you should do a will. Even if, as we've already discussed, the reason to do one is to appoint somebody that you want to manage your estate. If you have minor children, we definitely want to do a nomination of guardian for the minors. That's done within a will. People ask me, if I'm married, do I still need these documents? Well, the healthcare surrogate, the spouse is the first surrogate. So you could get by for a while without one. Living will is not automatic, even if you're married. So if you're married, nothing helps you with the living will. Power of attorney is not automatic, even if you're married. Spouse can't go deal with your bank account. You need a power of attorney. In a will, in estates, your spouse has the first preference for the personal representative. The spouse will inherit 100% unless you have children who are not the children of the spouse, in which case the spouse gets half, the kids get half. Nomination of guardian for the minor, the other bio parent, of course, has the first right to be guardian. After that, you're going to have to fight about it. So, even if those automatic defaults are okay with you, consider this. here you are. Here's your spouse. You go on like this for a long time, and then one of you passes, and it's just you. Now what? Now you're going to have to go out and do all these things that I told you today you should do. Right? And it actually is going to get worse. So consider this. Right? You're here. Your spouse is here. You pass away. Everything goes to your spouse. None of you did any of this. And now it goes to your spouse's blood family. So everybody who tells me I'm okay because I'm married, the minute I tell them this, they're, where do I get this done? Because this is what will happen. So you can't consider just today. And part of what I say to people is, you know, in all likelihood, you're going to stay together for a very long time. And when one of you passes, it's going to be the worst day for the survivor. And you want to run out and do life planning like that after you leave the funeral home, where you go through that agonizing process and they say it'll be $10,000, how will you pay today? No. So, everybody should do these things. At least these simple kinds of things. Now, there are some things, we have a question.
So, to get like a package plan, to get that whole thing, what does something like that cost, you know, with your services? Like, hey, I need you to do these, a lot of things.
I'm going to go over that a little bit differently, but so with me, if what you need is straightforward, there's no, we got to deal with disabled relatives and children and Medicaid planning and all this sort of thing, then the cost of the package of a healthcare surrogate, a living will, a power of attorney, a will, a nomination of guardian if you need it, and then something I'm going to go over, an appointment of agents for disposition of remains if you need it, is $750. If you come in the office and you sit down, you talk to me and Colleen about the details of that. If what you need is simple, and you already know who you want to appoint and who you want to be your beneficiaries, then you can go to another website that we started called mysimplelifeplan.com and fill out a form that puts all that information down, and it's $375. So I'm going to go over that again later, and then I have some brochures up here. So if you need the consultation to discuss the details of this, it's $750. If you already know, do the online form, and it's $375.
One more question. So you were talking about that power of attorney. Say you don't have relatives or anyone to leave stuff to, you know, you want your attorney, which would be you, to take over everything. Is that like extra from the $750?
Well, the question is, what if you don't really have anybody that you want to appoint and you want to appoint the attorney? A couple things about that. First of all, I'm not crazy about being that person because my practice is not set up to manage your banking and your affairs day to day. So what I usually recommend is that you appoint a professional fiduciary. Now they charge when they do the work. So there's no maintenance fees or things like that. And they do charge, so there has to be some funds to pay them, but you can appoint a professional fiduciary to do that. You can appoint friends. It doesn't have to be a relative.
What if you set up the will and things change and you want to change it? How much does it cost to change the will?
It depends on how much does it cost to change a will, is the question. If I did it, I have it on my computer. So if we think about it, it's not that hard to change. So the cost is not the same as originally. It just depends on what has to be done. If it's simply changing the name of your personal representative or something, the fee can be nominal, $100, $150. If it's more complex, it depends on what it is.
Just curious, did you change it yourself and have it notarized? Would that be legal?
Well, no, because a will, you can do it yourself, but a will has to be witnessed by 2 people, and if you do what's called a self-proving affidavit, which you should do, you have to have 2 people and a separate notary. So when I go and look at willsandtrusts.com, and their first selling point is you can get this signed at your convenience, let me just ask you, how convenient is it to find 2 witnesses and a notary in the same place? I've done it, and I don't think it's that convenient. You know, so it's the execution of it that you have to get correct. And you cannot mark something out of a will and then initial it. You can't do that. That won't work. The original, excuse me, the original provision will apply. So you can't do that. Here's a document that some people should have. This is a designation of agent for disposition of remains. This is a lovely topic here. What do we do with you when you're no longer breathing? Okay. So somebody has to make those arrangements. And in Florida, that's governed by the funeral home statutes, and it falls to your blood family. So if you don't want your blood family making your final arrangements, we do this document that appoints somebody to do it.
What if you already have that set up? Nobody can change that, can they?
No one else can change it if you have it set up.
Like if you choose cremation, like I already got it all set up, someone can come and say, well, we're going to bury her instead?
Well, can somebody come and say, we're going to bury you when you already chose cremation and you had it set up? Now, I don't know what you mean by had it set up. If you prepaid it and prearranged it, no, it's over.
Okay.
That's what happens. That's the best thing to do. And in fact, prearranging your cremation or your burial is a gift you give to the people you leave behind. Because they make one phone call and it's over. Question?
Not a question, but a comment. My mom passed away a little over a month ago, and I still have my dad, but we were just so blessed because they had everything put in place, prepaid, prearranged, the whole bit, and it made my sister and my life just that much more bearable to not have to even add on to, you know, everything else.
Exactly. Prearranging your final arrangements is truly a kind thing to do for people. I've done mine. And there's somebody who talks about these prearrangements on the internet. Let me see if I can get this right. Talking about sex doesn't make you pregnant any more than talking about cremation makes you dead. So we get superstitious about this, but it really is a kind thing to do for your family, because then when we do pass, our family and our friends can celebrate us, and they do not have to get stuck in making all those arrangements. But if you don't have it done, and even if you're inclined to do it, I understand human nature. I would do the designation of agent for disposition of remains, so we have that person taken care of. Some people should have a pre-need nomination of guardian. We've talked about that. Some people should have a revocable living trust. A trust is a document that will hold your assets now while you manage them. Will continue to hold your assets if you are incapacitated, and the person you designate will manage your assets for your benefit as long as you're alive, and it will hold your assets and distribute them after you pass. So a revocable living trust does that for people. Some people should have business documents, such as bylaws or operating agreements. So a lot of people forget this. They go on SunBiz and they create their company, but they never do an operating agreement for their limited liability company or bylaws for their corporation, and they never think about how is that going to pass when they do. Some people need property documents, such as deeds or a land trust. Deeds can put joint owners on a property. We can, under some circumstances, add a beneficiary to a deed. A land trust will protect your investment properties from liability, and it will also, if you want to get anonymity, it'll give you anonymity. Some people need asset protection documents, some things to make sure that nobody can get at your assets. If you're concerned about that, we should talk about that. So why do you need these documents? And we've already talked about this, so I'm going to move through this pretty quickly. But if you think about it, if I'm ill or injured, who's going to go with me to the doctor or the hospital? Who's going to talk to the doctors and nurses if I can't? Who's going to tell my friends and my family how I am? Who's going to pay my bills? Who's going to take care of my pets? And how are they going to do that? So, if you don't have a designated healthcare surrogate, the answer is it's going to be your spouse or your blood family who's going to take care of your health care. Nobody's going to tell your friends unless your family lets them know. Nobody can pay your bills unless you have a power of attorney. And anyone can care for your pets if they're willing to steal them and pretend that they belong to them. So everyone should have a health care surrogate and a power of attorney. If you die, who's going to make your final arrangements? Who's going to pay your rent or mortgage? Who's going to dispose of your personal property? Who's going to sell or receive your home? Who's going to take care of your pets? Have you noticed that I'm trying to get you to pay attention to your pets? I just got stuck at a vet this morning with some 14-year-old cats that I'm fostering because their mommy died and their daddy had to go to a nursing home. So a rescue took them in and they were terrified in a cage, and so I said I would foster them. So, unless you get the bleeding hearts, better you figure out what's going to happen to your pets. And how are they going to do that, right? If you don't have a will or a trust, again, all of this is going to fall to your blood family, or it's not going to happen at all. So, if I haven't made my point that I think everybody needs a will, let me try to make it again. Even with a will, you cannot disinherit your spouse. Your spouse is entitled to at least 30% of everything, plus a life estate in the homestead. Without a will, if you have children from another marriage or relationship, your spouse inherits 50%, and the children get 50%. If you don't have those children, the spouse gets 100%. With a will, as long as your spouse receives 30%, you can leave the rest to anybody you want to. If you do have no spouse or minor children, you can leave the assets to anybody or to any charity. Without a will, we're going to find blood relatives somewhere, and they're going to get it. People tell me I don't want the state to get my money. No, it's worse than that. It could be your fourth cousin, twice removed. I don't do genealogy, so I don't know how we track those people down. But if you don't have a will, we might be. So these are the various kinds of documents for life planning. Just to put this in context, documents that apply only during your lifetime include a living will, that expires when you do, a health care surrogate, which expires when you do, a power of attorney, which expires when you do, and assets in your individual name are going to be frozen upon your death. Now, a will only applies after your death and after it is admitted to probate. The assets in your individual name are now going to pass under your will to your beneficiaries. If you want to know about the ever popular avoiding probate, here it is. So these particular documents apply during your lifetime and after your death. So that includes an inter vivos or living trust, a revocable trust. That includes assets with joint names, because they will pass to the joint owner, and it includes assets with a beneficiary like life insurance. That will pass to the beneficiary, all outside of probate. If you want to avoid probate, you can put your assets in joint names. You can add a beneficiary to your assets, or you can create an inter vivos or living trust. In that case, they're all going to pass outside probate to the beneficiaries that you say. So here is the Simple Life Plan, mysimplelifeplan.com that I told you about. It includes a simple will, healthcare directives, a power of attorney. It would also include a designation of agent, excuse me, for disposition of remains if you need that. And then that is $375, half the regular price. I want to throw in just a little bit about elder law, because we do live in a land of a lot of elderly people. So when we get to advanced age, now we should pay attention to planning for incapacity, absolutely. So everyone needs a power of attorney. If nursing home care becomes necessary, the average monthly cost is more than $9,700 a month. If you don't want us to drop $100 grand a year, you need to do some planning. To qualify for Medicaid, you have to spend all your assets except $2,000, and all income except $130 a month, all spousal assets except $130,380. These are the most recent benefits. However, there are alternatives to this. So my message to you is don't spend down your money. Talk to an elder law attorney, because there's a lot that we can do to help preserve assets and still qualify for Medicaid in a nursing home. These are the areas of law that we practice at Blackburn Law Firm, lifeplanlaw.com. We certainly do LGBT planning, elder law, probate, small business, asset protection, some real estate work, and of course, life planning. That is life planning documents for the LGBT community. I hope this has been of value to you and that you learned some things here today. Does anybody have any questions? Yes?
We don't know if we're married or not. We were married on May 20th, 2004. The first day it was legal in the U.S. and Massachusetts. Does that count as real marriage?
Absolutely. And it counts as of that date.
No, good.
Okay, so here's what happened in Obergefell. The United States Supreme Court said it is unconstitutional to refuse to recognize marriage. So when something is unconstitutional, it is what we call void ab initio, and is as if it never existed. So your marriage is valid all the way back to 2004.
Thanks.
Yep. So if you want to get in contact with us, here's many ways to do that. You can go to the website and contact us for a complimentary consultation. You can call our number. Please don't do that now. Monday would be a good time. You can go to mysimplelifeplan.com to start your reduced price Simple Life Plan. You can follow us on Facebook at Life Plan Law. Yes?
Should each individual, if they're married, have a separate will, or?
Should each individual, if you're married, have a separate will? Yes, there are no joint wills. There are joint trusts, but there are not joint wills. Question?
What is the difference between a will and a trust?
Oh, well, what's the difference between a will and a trust? A will says what happens to your assets after you die and after it's admitted to probate court. So it's only after you die, it's only after it's in court. A trust is effective as soon as you set it up. It's effective while you're managing it. It's effective if you're incapacitated, and it's effective after you die.
Right, so that's why my parents' thing is called the living trust.
Yes.
So there's difference.
And it was really easy that your parents set that up in a living trust, wasn't it? It makes things very easy and much quicker and less expensive. Yes.
I was lucky enough to be at a talk that you gave at the senior center at St. Petersburg about 4 years ago.
Uh-huh.
And I got all those documents set up that you mentioned today. And wondering how often do they have to be updated?
Or how often do your documents have to be updated? Well, that depends. So, first of all, if you have documents, if you have a power of attorney prior to 2011, you should update it. There was a major, major change in 2011. In Florida, you need a new power of attorney. There were some minor changes in 2015 to healthcare surrogates and powers of attorney that aren't critical. You may or may not want them. So those are the legal reasons why you should update that. But you should look at your documents and ask yourself, do they still carry out my wishes? If they're still applicable, the people you want to appoint are still the people you want to appoint. The beneficiaries are still the beneficiaries. There's no need to update them. Yeah, no magical time or number. Yes.
Is a will forever?
Yes, a will is forever.
So,
But here's the thing. Here's my begging you. Please, where's the original? We need the original. Don't lose it.
and what if the law firm stuff is no longer? How do you still, what do you do?
Oh, I don't know. Okay. I do deal with this way too often. What happens if the law firm that did your will is not in business anymore? Well, if you have your original, which with me you will, I don't automatically keep your original documents. I will keep them if you want me to, but I don't ordinarily. If your lawyer kept your original, try to contact somebody who knows where the firm where they were, or somebody who took over, their spouse. You can call the Florida bar. Individual lawyers are supposed to designate a custodian for our records if something happens to us. But that's the lawyer's responsibility, and most of the time they do not take care of it. It's a problem. So if your lawyer died and you can't find the lawyer or the original will, do another one. I'm sorry to say that, but you should.
Well, where you did the will a long time ago, pretty much nothing applies.
I'm sorry, can you speak up?
What if you did a will a long time ago and pretty much nothing applies?
And pretty much what?
Nothing applies now.
Well, now you should redo it. And if you want to revoke it, tear it up.
Okay.
That's the problem with the missing original will. Even if we have a copy, the presumption is, boy, that's good, isn't it? Okay, sorry. I should stop playing. The problem with not having the original will is there's a presumption in Florida law that you revoked it by tearing it up. And we have to prove why we think you didn't do that. Like there was a fire, like the lawyer had it and the lawyer died, etc. Yes?
If you're not married and living together, should you both have ordinances?
Yes, if you're not married and living together, should you both have all of this? The answer to that is yes. You didn't think I'd say no, did you? Yes.
So a will is drafted in Maryland. The attorney probably still has it. Situation is different, still not with the same person. I'm in Florida, he's somewhere else. The attorney still has the will as far as I know. What should I do, go to the attorney and tell her it's not effective anymore or not?
Well, so the question is that, you did a will in Maryland many years ago, the attorney has it, the circumstances no longer apply, what should you do? Have you done a new will?
For myself, I do, but my ex-partner, I don't know.
Right. Well, if you did a new will, your will revoke the prior will. So no lawyer writes a will that doesn't revoke prior wills. So that will not be effective. Just make sure we can find your new one. Yes. You can also tell the attorney to discard it, but you don't have to. Yes.
Is there a special place where you should store a will? I mean, let's say that is there a way where to put it so that you tell someone it stays there?
Where should you put your will? Okay, here's where not to put your will. Do not put it in a safe deposit box. That's a nightmare. Don't do that. Get something fireproof. You can get a fireproof box. If you have a safe at your home, trust me, people are looking for your money, so they'll open the safe, right? But if you don't have a safe at home, if you do have one, put your will there. If you don't have one, buy a fireproof box. You can buy a fireproof small safe. Here's my recommendation: do not lock it. It'll still be fireproof, but burglars, if they come in, if it's not locked, they'll open it, they'll see it's your will, they will go boring and leave it. Right? If it's locked, they'll think it's cash or drugs, and they will take it. So, anything else? Well, thank you very, very much. I appreciate you being here. By the way, we do have some booklets up there that I did write. We have the life planning guide and a financial and digital accounts log that lets you write down your passwords and where your accounts are, which is going to be critical today. And for people watching on live stream, these are available on the website. So you can download them from there. So I suggest, if you want information on these documents, the life planning guide, if you would like the rest of us not to commit suicide after you're gone looking for your passwords, please write them there. Thanks.